Good afternoon, everyone, and a very warm welcome to today's webinar. So this is all going to be focused around the UK Employment Rights Bill, hidden risks you need to know about and how to action. So just a bit of housekeeping before we get started. So if you could give us the thumbs up if you can hear us and see us okay, that'd be super appreciated. Yeah, we've definitely got some thumbs up, so thank you for that. Now, we're going to be recording today's session and we'll send it out to you afterwards, so don't worry about taking lots of notes. We know how complicated some of these conversations get. But if you've got any questions along the way, use the Q&A button at the top of your screen. We'll have some time at the end to go through as many as we can, and we'll try and pick up some of the questions as we go through the slides as well. But most importantly, sit back, grab a brew or a cuppa, depending on where you're from, and enjoy the session. So my name is Phill Anderson, and I'm the Global HR Director at the Briars Group, and I help businesses in the UK and globally with HR, compliance and expansion services. But today is all about Jonathan. So I'm delighted to be joined by Jonathan Rennie, who's an employment law partner at Level Law. Jonathan's one of the top experts when it comes to employment legislation, so we're in really great hands today. Jonathan, over to you to introduce yourself, if you don't mind.
Yeah, good afternoon, everybody. I hope you're enjoying your sunny days and that we can give you some hints and tips today on how to prepare for the Employment Rights Bill. Principally, I suppose over the years I've become an employment tribunal litigator, and I've probably worked on, I would say, over 300 or 400 employment tribunals across the UK and England, and also in Scotland. So when I look at changes in the law, I'm always thinking, well, what's the practical impact? What will this mean in terms of volume of employment tribunals? How might organisations respond to that or try and take advance protective measures? So that's the position that I come from, where there isn't necessarily alarm bells in terms of the Employment Rights Bill, but it is intended to give more rights to employees, and possibly then the balance of power shifts a little bit in the employment relationship to employees. So remains to be seen how it impacts in practice, but I'm happy to chat with you all on the hot topics.
Amazing. Thanks, Jonathan. I really appreciate that. So we'll be together for about 30 to 45 minutes today, and we'll explore the key changes in the new bill, the risks businesses like yourselves may not have spotted, but most importantly, those practical actions you can take to stay ahead. So we'll finish today by answering some of the fantastic questions you've already submitted in advance. But like I said, if you've got any more, please just use the Q&A function at the top of your screen, and we'll do our best to get through them. So we'll get through this so you can enjoy some of the sun today. But let's get cracking. So what is the UK Employment Rights Bill? So let's start with the basics. So Jonathan, could you give us a bit of an overview of what exactly is the Employment Rights Bill trying to achieve, and why is it such a fundamental landmark for employees in the UK?
Well, I suppose having worked in this area for 20 years and the history of looking at things like the gig economy, employment rights, the last major review was the Taylor Report in 2017, which talked about good work for all. But ultimately, that document wasn't very specific and didn't necessarily lead to legislative change. So, in terms of the Labour Party's manifesto, they committed to a 100-day action plan, and in the first 100 days wanted to introduce this bill to the House of Commons. And it's absolutely enormous. I was listening to a Labour MP describe this bill as joyous but complicated. It's a very funny expression that. There's so much to it, and it will be coming in incrementally over the next 2 years. So certainly we might tune our ears into things like day one unfair dismissal, and as HR employment law practitioners feel a sense of urgency about that. But conceivably, that could be the back end of 2026. So we know that the bill was discussed or debated in the House of Lords yesterday. There's another day of debate at the start of May, and I think on May the 14th, the final and third day in the House of Lords. And then the proper word is ping pong between the House of Lords and House of Commons, such that the bill might become an act most likely September, possibly even October, because of course the House of Commons is shut over the summer. So that was the plan, to reshape work, to provide greater stability, greater employment rights, and obviously there's been some landmark employment issues in the last number of years. So the one that will possibly touch on is the P&O Ferries company, where I think in March 23 they dismissed 800 people, and that was seen to be a bit of a blight on UK employment law.
So these changes then haven't necessarily just come out of nowhere, have they? They've been a direct response, if you like, to some pretty big shifts in how people are working. Could you perhaps talk us through then why the bill's happening now then, and what's been driving the reforms? I think you probably touched on a little bit of in
Yeah,
the
it's fine.
previous
It's
slide.
fine, Phil. Yeah, it's interesting to see the Uber case mentioned there, because it's one of the chunkier cases that I read on employment status, and the blurred distinction between worker and an employee, which it can be difficult to absolutely pin down, and sometimes employers exploit it. But in the Uber case, Uber came in for significant criticism in terms of trying to categorize people as self-employed contractors and not really paying them properly when they had worker rights and entitlement to holiday and national minimum wage, etc. And I suppose when you look at the companies that are named in these litigations, they're often global, very well funded organizations that aren't necessarily headquartered in the UK, and therefore maybe choose to try and take advantage of labour relations in the UK. So I think organizations potentially have been trying to exploit, or let's say push the boundaries of UK employment law in terms of how they treat staff, and we know that that's led to instability. And of course, we hear the words about flexibility in employment and engagement, but sometimes that flexibility is creating instability where people don't know if they've got guaranteed hours, they don't know their earnings, etc. So I think the CIPD have done a lot of research on the idea of employee voice, and actually individual and collectively employees have been arguing for stronger rights, and the Labour government has followed through in that in terms of the bill. I suppose when I start talking about politics, and I'm not going to say any more than this, the issue with the bill is really the implementation and whether the employment tribunal system, for example, is sufficiently well funded to deal with all the changes. So that's where that language of teething problems might appear naturally when we think, there's going to be changes that come in October. How does ACAS deal with that? Do they have enough staff? How do employment tribunals manage the potential uptake in claims? So there's going to be a little bit of push and pull. It's definitely interesting to see how that settles down. I suspect some employees will feel that they're more strongly armed in terms of pushing employers.
So there's an awful lot packed into this bill, isn't there? So
Yeah.
if we start thinking about breaking down what those big shifts are, then could you perhaps sort of take us through at a high level what those headline changes are, and perhaps for everyone who's on the webinar today, highlight which ones are likely to have the biggest impact day to day, and the ones that they need to have at the back of their mind.
Yeah, well, listen, I've got a sort of timetable in here that we might share after the webinar, which talks about day one unfair dismissal potentially coming in kind of October 2026. That's when it's predicted to come in. Well, even on the 1st of October 2026, people had day one unfair dismissal rights. That basically means that people that are employed now in your organization, when you're onboarding them, they will have unfair dismissal rights on the 1st of October 2026 if that is the date. So that means there should be some advanced planning around that, rather than waiting to that implementation date when it's across the board. So there's that type of thinking. I suppose the issue with day one rights is that it sounds fantastic. Like, I suppose as a headline, it sounds like employees are really empowered and have a strength there. The detail of this isn't absolutely precise, meaning that there might be some form of what's called a lighter touch process to managing issues in the first, I think, 9 months has been sort of put out there as being a period where there might be a lighter touch process that employers can follow. There's going to have to be an ACAS code of practice. And I think for me, when I think about day one rights, just as I say, from a litigation perspective, I think, okay, so say somebody was dismissed on day one. Well, I mean, they have to go and mitigate their loss and go and get a new job. So conceivably, it might be difficult for them to say that they've lost out on a future income if they've been immediately terminated. And if they've just come out the job market, maybe it's easier for them to enter into recruitment processes. I think we all know if somebody's been working for 20 years and is dismissed, they're going to maybe struggle with interviews. They maybe need outplacement consulting. They maybe aren't feeling very confident versus somebody that's just gone through that whole process. So I think there's practical elements to that. But of course, it does mean that potentially somebody might go and raise a tribunal after joining and after being dismissed. So there will need to be an ACAS code of practice on that, and that's why that will take time. So when we hear sound bites, I was going to say in the radio, maybe it's just me that listens to the radio.
I
No,
think we
no,
all
I
still
didn't
listen
say
to the radio.
I didn't say the word wireless, Phil. I said radio, but yeah, there'll be sound bites that we hear on social media, on the TV, whatever, around day one rights, but it's not going to be quick because who's to say that ACAS can produce this code of practice? It's not the easiest thing to define what is lighter touch. To me, it sounds really classic employment law of using nice language, but if we need to know what the detail of that is. So yeah, aside from that, fire and rehire, which we'll talk about in a moment, would be a massive shift. And the new Fair Work Agency is an interesting one. I think, racking my brains here, in Northern Ireland, there might have been a sort of similar statutory body in respect to some of their discrimination rules. But the idea of the Fair Work Agency is that there might be the establishment of a body that can raise claims on behalf of individuals that don't want to do them. It's kind of a difficult one for me to get my head around. I mean, normally, if an individual either wants to raise a claim or they don't, but it might be that this body can step in and raise actions. There is, of course, the Equality and Human Rights Commission, the HRC, that can take discrimination claims and sponsor claims, and there's been some high value, high profile claims that they've been involved in. So the creation of a new body obviously isn't a fast thing. On my list, that's like a 2027 idea. What I'd like to see, and isn't on the slide, is more investment in the employment tribunal system, which would enable all of these processes to be a bit more effective in practice.
And would you expect that sort of investment to come following a lot of these changes in the tribunal system? Because I have quite a lot of conversations at the minute around the slowness of the tribunal system, lack of response. If we added more opportunity to raise claims, it's going to make the problem worse in the future. Do you see that sort of investment coming in?
I mean, I would love that because it would make life easier. But then I'm aware that I was at a seminar with a barrister who said, well, education, transport, health, there's other government spending priorities. So when you think about it in that way, you can see that there's only so much money that can be distributed. But there's no doubt the employment tribunal system is creaking. What I find is that it varies geographically. So you can have occasionally good responses from one tribunal. I'm not going to name them actually, and then really poor responses from others. But what I would say, particularly around London, where I think there's the London South, London Central, London East numbers of tribunals. You might be looking at cases being raised today that are heard in 18 months, 2 years time. So it is difficult, and I guess that's the tension here that employees might feel, well, there's new rights, new ability to raise claims, but then find that they get clogged up in the system. So that's why it is quite political. But one of the things they certainly tried to do in the Scottish tribunals was introduce a fast track procedure for wages claims, which worked quite effectively and sort of managed to unclog the system. Occasionally, it's pointed out that the tribunal runs from 10 a.m. to 4 p.m. with a 1 hour lunch, and possibly it could run longer. Little things around the edges might make a difference.
Okay, so let's sort of, as with any change, the real risk really isn't necessarily what is obvious, but it's stuff we often overlook, isn't it, Jonathan? So if we think about hidden pitfalls, getting it wrong, what's the sort of stuff on the slide perhaps we should pick out for the viewers, that they should be aware of? If you get it wrong, there's consequences.
Yeah, I think, well, principally there's going to be a reputational issue for the first employer that's caught out in fire and rehire, because that's what happened with P&O Ferries. In that particular scenario, I'm aware that the individuals received very generous settlement agreements. Of course, they've signed non-disclosure agreements, so that isn't commonly known. So I think there's the idea of being an employer of choice and the recruitment benefit of following through and all the proper practices. So I think employers would want to be aligned with that. Um, I guess, yeah, there is a financial cost to implementing these changes. Difficult for me to kind of calculate that out. I think ACAS estimate that the changes to day one rights and the changes to tribunal time limits suggest there'll be a 15% uptick in employment tribunal litigation. So certainly employers might choose to ring fence budget. That might be wishful thinking. Like it's easy for me to say, put some money aside for potential tribunals. Think if you were sitting in the room when that was debated, you might think, oh, good, I'll help myself to some of that money by raising a tribunal. So yeah, they're difficult conversations to be had. Um, and there's sort of specific details that will help employers protect themselves through changes to policies, which we'll talk about in a moment.
That's great. That's great. So let's talk about perhaps like that real world impact then on people then. So if we just think from frontline to leadership teams, these changes are, and I suppose they're already rippling through organisations. I'm having a lot of conversations around this bill already, and they'll probably continue for the short to medium term future as well. But what sort of real world impact should HR teams, managers, leaders be preparing for in your view, Jonathan?
Well, I think there's an internal job for HR to do to draw attention to the fact that there's such massive changes. I mean, we know through COVID, HR and people issues became top of the agenda, and I think rightly so. But from time to time, HR falls into, I perceive, the kind of business as usual or whatever other type of language you want to use. So it's an opportunity for HR teams and HR leaders to get on the front foot and to say, look, we're going to need to make some changes. We're going to need to invest in our policies and procedures. The slide talks about rethinking the working model. That will be the case for 0 hours and employers that use agency workers. So I think, Phil, you and I might do another session on that because the gig economy is obviously enormous. But I think the evolution of the bill has been such that 0 hours contract workers were to be given guaranteed hours. And then as the bill was developed, agency workers were afforded that benefit also because there was a concern that organisations would shift their 0 hours workers onto agency contracts. So that can have a big change on the model, on the choice of labour, if you like, which I know is quite a US expression, but just the flexibility of the labour market might change. It might lead to individuals choosing to work in a different way, and I suppose that can have an element of competition between different employers.
Okay, great. That's great. So let's get into the real detail, I suppose. So I think something that me and Jonathan often discuss is what we're sort of calling the big three. So this is three major changes under the Employment Rights Bill that no doubt will have a pretty big operational and financial impact for employers. So each one of these reforms, if you like, is going to touch a core area of employment law. And while that might sound pretty straightforward on the face of it, they actually come with some pretty real world complexity that you need to be aware of. I need to be aware of. So we'll take each one in turn, and Jonathan will help us unpack each one, what's changing, and crucially what that means in practice. But if we start with the first one, which is that fire and rehire abolition piece. So fire and rehire has been hugely controversial for a while now, and I've had lots of conversations with previous clients and current clients all around this, and now it's effectively abolished under the bill. So, Jonathan, could you perhaps break down what's changing here and what that practically means for businesses, for example, looking to renegotiate terms, as an example?
Yeah, so it used to be the case that under the Employment Rights Act, you had the fair reasons for dismissal, conduct capability, redundancy, and some other substantial reason. And within that some other substantial reason subsection, there was the ability to fire and rehire staff, which is essentially defined as trying to vary their terms and conditions. And then if they don't agree to the variation, just terminating them, which would be a fair dismissal under that SOS or some other substantial reason um, headline and wouldn't involve any kind of redundancy payment. So certainly, I'm just going to say because I'm ancient, in 2008 when there was the financial crisis. Numbers of my clients used this tool to reduce pay. So it might be that they look to reduce pay by 20%, and then if a person didn't agree to that, they'd be served with a notice of termination and a re-engagement letter that said, if you don't sign up to this within your notice period, then you will be fairly dismissed. And that was a very effective tool for employers. So that's pre the P&O Ferries case, which had so much publicity. And at the time in 2008, it felt to me like that was almost a normal thing that employers were doing. And it was a very easy piece of advice for employment lawyers. Of course, there had to be consultation, there had to be a genuine business rationale. So it just became a formulaic tool for employers to use. But I'm not going to read the section from the bill, but I've got it in front of me, and it's basically going to be an unfair dismissal, an automatically unfair dismissal, to dismiss an employee where they've refused to accept a variation to terms. And the carve out for that is so exceptional that we don't really think an employer is ever going to rely upon it, which is that um, they have to be suffering from financial difficulties which are likely to affect the immediate future of the business. And that feels like very close to an insolvency type situation, and the burden of proof on that would be very, very high. So that's the scenario, that option of trying to vary in terms and conditions, and then with the threat, because that's what it is, the threat of dismissal that makes people sign up. You know, if somebody chooses not to sign and they're dismissed, that's automatically unfair. I know I'm being repetitious on that, but it's just because it's been a method of varying terms that employers have used quite freely for a number of years. So if that is the case, and this is the hints and tips section, what do employers do? Well, uh, they might try and vary terms and conditions before the law changes. So Phill and I have talked about this. I've had 2 or 3 clients, some employers, some employees, be in touch with me over the last couple of weeks where, surprise, surprise, organizations are looking to make the changes now, and they're looking to threaten dismissal because they're aware that this might come in September time and they want to just get this lined up now. So organizations can still use this tool, but it's a very diminishing window, and presumably nobody wants to be in the scenario 1 week before the new law comes into effect, trying to impose all these changes. So that if there is a window of opportunity to do this, it's over the next 3 or 4 months. If organizations don't want to do that, because it's always described as a nuclear option, then they might look at their variation clauses. So we're talking about those variation or flexibility clauses in contracts of employment and try and ascertain, well, how specific are they? Sometimes they're quite vague, but there might be a case of adjusting the variation clauses in contracts and policies to give greater ability to vary, or greater argument to say, hey, you signed up to this clause. This is me talking about after the implementation of the new law. So my top tip in that regard, which we can share now and we can share to follow up, is there was a case, pretty well-known case. It was the ASDA case of Bateman. So Bateman's Bateman, which went to the Court of Appeal in 2010. So 2010 was a long time ago, but it's still a really effective case authority where there is actually the Court of Appeal endorsing a variation clause, which said, you know, the employer reserves the right to review, amend, adjust all terms and conditions, including pay. And ASDA successfully relied upon that and successfully defended litigation by saying that they were entirely justified to vary terms. So employers can look at that now. Obviously, if an employer suddenly changes its variation clause and lets staff know that, it's kind of a red flag as to what's following next. But the ASDA Bateman case has the specific language that employers might choose to borrow, that gives them that opportunity to make variations and potentially avoid the fire and rehire threat. I have heard it. I've heard it being suggested that some organizations might just take the risk of the automatic unfair dismissal, which sounds a bit weird. But if an organization has made a small change to terms and conditions, I'm just going to say, for the sake of argument, remove the shift premium or removed a cycle to work scheme, something like this, and it's ended up in a dismissal situation. Well, the individual still has the ability to mitigate their loss by taking that change of terms and conditions. So you might find some employers think, well, yeah, I know it's aggressive tactic, but we might just follow through in this anyway. And if individuals raise claims, they might be very low value, and we might either settle them off or we might just deal with them in 18 months. So there's some practical thinking there. And again, it's not for me necessarily to talk about like good employers or bad employers, but yeah, there's a window now to vary terms before the new law comes in.
And that delay in dealing with claims as well comes into check as well, doesn't it? As in, employers might think, actually, like you suggested, we'll just take the calculated risk, one, because we're comfortable doing so, but also it's going to take, like you said, 18 months, two
Yeah.
years to even get into the crux of what that actual case even looks like, doesn't it?
Yeah, I mean, life moves on, doesn't it? So somebody might feel really aggrieved about a change of a premium, and they might feel that they want to raise a claim, and then like being optimistic about it, maybe things improve, maybe they get a new job, maybe they look at the litigation and think actually it's not worth following through. So yeah, there is a bit of a balancing act, but I guess because the language fire and rehire sounds really strong, doesn't it? It's almost kind of like military
Yeah.
in the use of the words, and then prohibition, abolition feels very extreme, like the pendulum swung back all the other way. And that is true in terms of what's written in the legislation, but good variation clauses, acting now before the change happens are top tips. But then even once a change has happened, there might be a calculation of what the risk looks like.
Yeah, well, that, I suppose segues nicely into the next piece on time limit and tribunals. I suppose we've already touched on this a little bit during the course of this session, but I suppose extending those tribunal claim timeframes sounds straightforward, doesn't it, Jonathan, on the face of it? But actually, it could and probably will significantly shift that risk for businesses. But how should employers adapt to dealing with that longer window for potential claims? Maybe let's explore that for a little bit.
Yeah, so I mean, discrimination claims have already had a just and equitable extension to that 3 months, which judges were quite willing to grant. But once it's more publicly known that the time period is 6 months, it is likely to increase claims. I mean, at the moment, there would be scenarios where somebody was, off sick, stressed, or hadn't taken legal advice, or was on a holiday and they missed the deadline for lodging claims. So all of that's pretty obvious from the employee side. I think from the employer side, it might be that HR people look at their policies and procedures and think, right, does this mean we want to adjust anything in the way that we manage disciplinary or grievances? Because, we might, for example, take a little bit of a longer time if we think that assists us with risk mitigation for any tribunals. I think it's difficult to be precise on that unless we were looking at a particular case, but it might be that employers just take a little bit longer on some of their internal proceedings to maybe be mindful of that period. I think for me, the main concern I have around this is really in the field of data subject access requests or DSARs, because certainly in my working practice, I see quite an uptick in DSARs. And if the time period is longer for an employee to raise a claim, they have the potential to raise a DSAR and for the employer to be having to comply with that and issue all the documents in advance of someone raising a claim. So I know I'm using my hands here, but the individual claimant might be literally like, well, fantastic, because now I've got all this documentation, I can better specify my claim. Whereas at the moment, and people can challenge me on this, but sometimes employers are a wee bit sneaky with the DSAR, or just put in a fictional extension, or maybe don't give certain documents and just let that tick on as a kind of, oh, I'm sorry, I didn't realize there was another email, or oh, am I supposed to disclose my WhatsApps, or whatever kind of fictional response you want to generate. So I think that's an area where DSARs can be very expensive. In terms of time, if you're doing them internally, it can be expensive if you're using external advisors. So I think looking at how you manage DSARs is important in light of the time limit. And I'm sure there will be people on the call that will be thinking, well, we've never had a DSAR. This is a lawyer, sort of alarm bells. Honestly, I've started doing more employee work as well, and it is such a strong tool because organizations just don't want to go through all the records, and then when they do, they realize there's a smoking gun email. So I think this is like looking at your internal processes, thinking if you would build in a bit more time. You know, if somebody was dismissed and they raised a post-dismissal grievance, you know, would you look at managing that any differently, and probably just bouncing around some ideas on it.
Yeah, I've definitely seen an increase around the DSARs, especially because there's so many ways in which we communicate with our people and our employees now, whether it's Teams, it's instant messaging, it's emails, it's video, it's that time element you've just touched on. It takes so much time, doesn't it, pulling one of those DSAR requests together, especially if they've got the understanding and knowledge of actually I want messages across Teams, instant message, email. It's something
Yeah.
definitely to reflect on and think about, isn't it?
Yeah, well, listen, Phil, if you were lodging a DSAR, you'd have the designation of your name, and how you spell it, and the different acronyms, and your various nicknames, which I don't know if you've got, but yeah, not trying to be
I've
not trying
got
to be too
plenty.
funny about it, but Jonathan can be John, Johnny, JR, what my acronym at level is WJR because there's another JR, and you get these unwieldy ones that yeah, lawyers, including myself, draft. But it's yeah, I'm going to use the language of it can be a sledgehammer in terms of time and recovery. And then you know that person, because of the extended time period, is now armed
Yeah.
and they can point to an email and say, well, this reveals that I was discriminated against, or, maybe even a lack of response to an email shows a disregard for treating someone fairly. So yeah, on the face of it, it's very easy to understand the extension. I think, yeah, as is said on the slide, the ACAS early conciliation period could extend that by a month. So yeah, it can be the case, therefore, that claims are quite extended.
Yeah. Okay, let's move on a little bit. So statutory sick pay changes. So this again on the face of it sounds pretty simple, doesn't it, Jonathan? So simple, but kind of a real, I suppose, cost and admin challenge attached to it, perhaps. So could you walk us perhaps through exactly what's changing and how employers could and should be preparing? Because I think looking at the time frame around on this one, this one could come pretty soon, couldn't it?
Yeah. So this seems pretty straightforward and is one of the changes that might come in the initial drafting of the Employment Rights Bill, converting to the Employment Rights Act, as it will be called. So yeah, so there's two elements to this. There's the removal of the lower earnings limit, sometimes see it as the LEL, such that everybody will be entitled to SSP, and it starts from day one, so there's no qualifying period. So employers paying for this will potentially have to pay out more. I suppose the tip for this is really not so much just changing any policies to reflect, the statutory position. Sometimes a handbook might just say we pay SSP in accordance with the statutory rules, and therefore you're not needing to make a change. But for me, the issue here, despite the slide being called statutory sick pay, is really around enhanced contractual pay. So if an employer is paying, full pay, where people were off sick, and if the handbook currently says that enhanced pay will be paid in accordance with the statutory sick pay rules, that effectively means the employer now will be paying full pay on day one. So that's a definite contract policy thing to check. I've made notes to myself here which are a bit I was going to say cheesy, but refer to duvet days and the idea of people who consistently take Fridays and Mondays off, and the fact that an analysis of sick records might reveal that pattern, and therefore those individuals could be benefiting from full company pay. So it's definitely a case of updating sickness absence policies, but thinking about what your specific contracts and policies say about enhanced pay so that you're not necessarily tripping up. Obviously, some organizations might be perfectly happy to pay enhanced full company sick pay. Others less so. Some organizations might already have a waiting period for this, but that's definitely the case to look at. And I suppose in terms of my notes here, aside from monitoring staff absences and looking at return to work interviews, I'd made a note that, there might be a need to update managers on this. They might not conceivably work in payroll. They might not know the back office implications of this, so that managers are aware of this change and the implications. So that if there are those people that take the Fridays and Mondays, listen, that used to be me occasionally back in the day. When I was in my 20s. But if being aware that has a cost to the organization, and it can be a cultural piece as well.
Yeah, definitely. That's really helpful, super helpful. I think it's been really insightful listening to your views on those three key topics for us. But if we turn our attention a little bit to what businesses can actually do next, I suppose if we explore what a straightforward, practical roadmap might look like in terms of preparing for some of these changes that we've discussed. And Jonathan, feel free to jump in at any point, but if we just go through in order, I suppose. So audit your contracts, your policies, your handbooks. So I'll probably start by reviewing all your employment documents, contracts, onboarding packs, HR policies, anything tied to a qualifying period, flexible working or sickness absence rule, probably needs a review and probably an update. So think about that one. Coming back to Jonathan's point he just made, train your managers and HR teams. And I suppose we're all guilty of this to a certain extent. We often all get this wrong. So your managers are your first line of defence. So make sure they really understand how to handle the likes of flexible working request, understand the dismissals under day one rights. I think it's really important that we get them comfortable to tackle some of the conversations that are happening not just necessarily today, but around the corner too. And reassess your workforce model. So going back to Jonathan's point earlier on, if you're using casual, gig, or 0 hour contracts heavily, now's probably the time to reassess that model. So new rights under that predictable working hours piece is going to require a bit more of a clear strategy from you. So start thinking it through now and really start thinking about tightening your dismissal procedures. So with day one unfair dismissal protection, probation processes need tightening. Don't start cutting corners now. Every performance discussion needs to be well documented from day one. If I reflect on my own experience and conversations that I have with a lot of UK-based clients, I hear too many times, Phil, we didn't have enough time to document, or we didn't think to document performance conversations. It's really important we do that now. It's really important. So let's make sure we do that one, and then start preparing for those higher tribunal risks. So longer claim windows typically mean you're going to need to get better at recording essential information quickly and transparently. So keep a paper trail for any employment decisions. Even informal notes will do. Just make sure we start documenting those sorts of conversations and building that flexibility and support model into everything you do. So flexibility and visible employee support isn't going to just be a cultural advantage anymore. It's almost going to be a legal necessity. So start getting ahead of some of that stuff by embedding flexibility into your working models. It's really important to get that bit right. And if you do all those and start your preparations now, like Jonathan and I are suggesting, you're going to be in a far more stronger position when this bill ultimately passes and we move through the next few months. So as we've already sort of articulated and shared, it's in the news. It's going to happen. It's just a question of when, really. But if we move on to some sort of pre-submitted Q&As, I think that'd be really helpful. So we've had some really excellent questions submitted ahead of time. So this is almost like our question time version, Jonathan. So you've got 60 seconds on the clock. I'm only joking. Let's just work through each one of these questions. And if anything else pops into the question chat, we'll try and cover those offers as well. But question number one, what happens if we don't update our policies, Jonathan?
Well, listen, not so much right now, but in the past, I would have seen, qualities policies that didn't really cover off the full range of protected characteristics under the Quality Act, or I'm sure we've all seen IT and communications policies that refer to facsimiles and things like this. So if the policies aren't up to date with the current law under the Employment Rights Bill and the Employment Rights Act, then it's just going to look immediately like the organisation isn't mindful of that. So it gives a little red flag if you were ever in a litigation situation or you're having difficult conversations with staff. That's my view of it.
And what do we think about whether or not these changes apply to remote or international workers? So I, for example, typically work with a number of international clients who have a UK base but have bases in other countries. Does this just apply to UK workers, or does it just extend beyond that?
Yeah, well, the jurisdiction of the act will be the UK, and it will be described as such in the initial paragraphs. But it is possible for individuals that are remote or international workers to have a sufficient connection to the UK, if their UK offices or place of work. So principally, they're going to apply to individuals that are, traditionally working within the UK, resident in the UK, but it is conceivable that somebody working overseas may be able to access them if there's a sufficient connection. Lawyers tend to say that's quite fact dependent, but there's case authority, particularly it was on North Sea offshore workers, for example, or international territorial water. So I think organisations really have to be alert to the changes and aware that the risks might capture more than just people within the UK border.
Yeah, great. And I think we probably touched on this a little bit during the course of today, but how do we manage dismissals with the new rules? So I think we've talked
Yeah.
about pace, haven't we? As it's maybe slow decision making and processes down a little bit and start documenting more performance conversations, perhaps more than you've done
Yeah.
before. But anything else you'd probably like to add there?
Well, it was interesting actually because we're coming at this from slightly different angles in terms of me with my litigation head on. Because you've been using the language of probation, which is absolutely right because that's what organisations should do. And yet I didn't pick up on it in terms of me discussing day one rights because as a sort of litigation person, I'm often looking at, well, do they have 2 years service? And numbers of organisations don't really look at the probation or don't follow through on it. So I think we're going to see in this lighter touch dismissal process and an ACAS code of practice probably a bit of focus on probationary periods. And so for those organisations that have, I'm using my, a little blah 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 with probation policies, that they should really tighten up. So I have heard guidance from barristers saying, before this comes into play, the new changes is an opportunity for organisations to really focus on that probationary period and maybe to, if they're not already doing it, to kind of try it out, test it, work with it so that they're in a better position when the changes come in. So I know that sounds a little patronizing, but I think if there's probationary periods already, then it's worth trying to like make that as good as it can be before the changes come in.
Right. I suppose last question just for the slide. We do have a couple in the chat, so we'll get to those shortly. But can we still reject flexible working requests, Jonathan? And this is a question I often get asked.
So, yeah, I mean, I know the one flexible working rights came in, I think, on the 6th of April last year, and there's still the defined set of reasons for the rejection. And it's a statutory set of rules, so organisations would often kind of clip those into to rejection letters. I think there's going to be a new code of practice that comes out where organisations have to be seen to be acting reasonably in their rejection. So I don't think it'll be quite as easy as just taking those statutory rules and saying, oh, unfortunately, we can't reallocate work amongst existing staff, or saying, sorry, due to pressure of business and volume, we can't manage that. So I think if we can see the direction of travel being to increase flexible working rights to day one, we can see that there's a kind of like family-friendly intention to increase those rights. So I think over time and with the changes in the Employment Rights Bill, as it becomes an act, it could become more difficult to reject.
Okay, great. So the answer is definitely not we can't. It's just we need to just put the appropriate process around it, don't we? Now, we do have two questions in the chat, Jonathan. I think we've got time to get through them. So first one from Amber Elliott. So can we still have 0-hour contracts if agreeable by both parties? For example, we've got a retired worker who is happy to help us out ad hoc when we're short-staffed, but doesn't want fixed dedicated hours. and wants flex to return, and wants flex to turn the hours down. So can we still have a 0-hour contract if
Yeah,
agreed with
sure.
that players?
Yeah, I mean, it's always helpful consent, isn't it? Because that looks like it's achievable. But I mean, my reading of the Employment Rights Bill, and we might do another session on this, is that 0 hours contract are going to have some component of guaranteed hours. That's the idea of increasing stability. So in the scenario that's presented there, of course, it sounds like, well, that's all fine, agreement's been reached. But I guess that across a population of workers, the intention is to have more guaranteed hours and better protections for that class of workers. So I think there might be a struggle in achieving that objective, but I think it would be one we would update on in our next session. That's a very well framed question because it kind of lends itself to the answer. Oh, if you're okay with it and I'm okay with it, we're all okay with it. Of course, you might get away with that, but I think strictly that it might not be entirely compliant with the new Employment Rights Bill.
Okay, great. And then question from Chris Fay. So this is, if agencies transfer their PAYE temps / contractors to an umbrella company, will that push these new rights onto the umbrella company? So that's if agencies transfer their PAYE temps contractors to an umbrella company, will that push the new rights onto the umbrella company?
I think I would have to go away and look at that, Chris, because I don't want to say something that's like a little bit of a guess on that, I'm afraid. I think the changes around 0 hours and the way that affects agency workers could be quite a big industry issue. I attended a barrister session earlier in the week, and the thinking on that was that possibly the way that the bill's structured doesn't make a lot of sense. And I know that feels like I'm trying to wriggle out of this one, but there could be changes on that point through the House of Lords and the House of Commons process. So I think if we know that the bill will be finalised on May the 14th, you're right to ask the question around agency workers, but I'm not sure we'll specifically know until that point. And I know when I see language of umbrella company, I start to think about tax and other things. So I think we'll undertake to update you on that in due course.
Amazing. Great question, Chris. Thank you for that. So I think just before we wrap up then, let's just, I suppose, quickly recap the key points from today. So I think just to reiterate, the Employment Rights Bill is a major shift that every UK employer needs to be aware of. The day one rights is going to transform hiring, onboarding and dismissals. I think a few other key takeaways. Flexible working is going to be a default right, and I think that comes back to what Jonathan's just articulated. The fire and rehire tactics are going to be significantly restricted in the future, and statutory sick pay will apply more widely from day one. And I suppose the last takeaway point is the risk of tribunal claims is going to rise more likely, and it's going to have longer time limits. But I suppose if you've listened to everything that me and Jonathan said today and thought, where on earth do I start, or maybe have some additional questions or concerns, don't worry. Briars and Level Law can help you navigate through some of these changes with confidence. So at Briars, me and my team can work with you on tailored HR audits and review and refresh your contracts, policies, your working practices. And if you need it, we can also offer some support on that strategic HR element to embed flexibility, fairness, compliance into perhaps your people strategy. And Level Law can support you by providing clear advice, employment advice that is, around the bill's impact. And I suppose more importantly, which perhaps we've not touched on, is helping you manage some of those high risk areas like complex dismissals, tribunal defence. So I think together we offer a really comprehensive HR and legal partnership to sort of give you that complete protection and not just piecemeal advice. So I suppose just one final point from me to make it even easier for you, please just take advantage of our complimentary health check. It's quick. It's a powerful review where we can assess your contracts, your policies, your workforce structure, your risk and exposure under the new rules. And we can also sort of discuss and figure out your management readiness for flexible working, sick pay, dismissals, and the things that Jonathan and I have gone through today. But I suppose just the final close. Huge thank you to Jonathan for his fantastic insights today, and for all of you for joining us, especially on probably the hottest day of the year. I've really enjoyed it. I've learned a lot myself. This is going to be a real opportunity for us all to sort of strengthen our people practices. Yes, we know it's a challenge, but let's just take the opportunity. In terms of moving forward, this is going to be probably one of a number of different webinars we're going to be doing in the future. So drop us a like and a follow on LinkedIn, and we can keep you abreast of any changes in any future sessions in the future. But again, thanks for today. Thanks for the questions. Thanks for the engagement, and thanks for listening. It's been great.
Thanks, everyone. Take care.
Thank you. Take care, everyone.
Bye-bye.